name is Paul Jordan. I'm a partner in the brands team, and I would like to welcome you all to our brands review of the year 2022. In this webinar, we will be highlighting 5 of the key cases that are contained within our wider publication. And in turn, I'll be introducing various members of the team that will be speaking to those cases. Before I do that, I'd like to very quickly introduce you to 2 of my partners, Ian Grissell and Nellie Jackson. Ian and Nellie have kindly agreed just to review what's been happening over the last 12 months, some of the hot topics and key cases, and also with an eye on the coming year, what you might want to look out for within your trademark practice. So starting with you, Nellie, if you wouldn't mind just sharing with us some of your thoughts and highlights over the last year.
Thanks, PJ. Well, despite the continued challenges over the past year with the pandemic, we've found that the brands world has remained particularly busy. Perhaps less travel has meant that there's been more time for innovation, product development and the like, but we've certainly seen that Brexit has continued to play a part, with a significant increase in the UK national trademark filings, and likewise a significant rise in contentious UK proceedings. One trend that we have seen in terms of the proceedings over the past few years is an increase in pleadings on the basis of bad faith. And we've highlighted a few of these cases in our review publication, such as the ongoing dispute between Sky and Skykick, the invalidation action against Banksy's Laugh Now work, and also the monopoly case that Sean is going to highlight in further detail during the presentation. And finally, one particular highlight for Bristow's over the past year is the Oatly case, where we represented Glebe Farm, a small British oat producer, successfully defending a trademark infringement and passing off claim in a typical David and Goliath type scenario that Sarah will highlight in further detail during the presentation. So I hope you enjoy.
Thank you, Nellie. And Ian, from your perspective, what are some of the things we should look out for over the coming year?
Yeah, thank you, PJ. I mean, we appear to be living in a rather uncertain world, dealing with multiple global issues, and that even impacts on the wonderful world of trademarks. Three kind of areas I'd just like to highlight briefly. Obviously, the last couple of years dealing with the COVID outbreak has been really tricky. Trademark offices around the world, as our own offices around the world, have been closing and reopening and closing and reopening again, just trying to deal with the kind of impact of the kind of the health issues. I just think going forward, you need to be aware in the short term that there will continue to be delays in the processing of trademarks and trademark oppositions before many trademark offices around the world. So there is a slowdown of the processes at this moment in time. So just keep an eye on that. Turning to the concerning developments between Russia and the Ukraine, there's been an awful lot in the media about the Russian government's approach to intellectual property owned by Western companies. There was a decree number 299 that it appears to allow for the exploitation of a certain IP, almost a compulsory license type situation. It does not cover trademarks at this moment in time. However, we have seen an awful lot of media attention on a Peppa Pig case, the children's cartoon character, that appeared to suggest that a decision by the Provincial Arbitration Court in Kirov suggested that politics would be taken into consideration when the decision was issued to the detriment of a Western company. Now, this decision has been appealed and it's been heavily criticised by the IP legal community in Russia. So I don't think that this is something precedent that we need to be concerned about, but it's certainly important that we keep an eye on what is going on both in Russia at the statute level, but also by the courts around the country. And finally, I'm afraid I'm going to mention Brexit, as I've mentioned in previous years. Just as we move forward, we need to be more conscious and aware of the non-use provisions for both the cloned UK trademarks that you will have and the remaining EU trademarks. So conversations with your IP lawyers about how you are using or not using your trademarks in the UK and the EU would be really important.
Thank you very much, Ian. Thank you very much, Nellie. I'd now like to get started with our first speaker today, Senior Associate Sean Ibbotson, who will be talking to you all about the Hasbro case. Enjoy.
Hi everyone, my name's Sean Ibbotson, and I'm going to talk today about the Hasbro case, which reached the General Court last year. It's a decision about the monopoly trademark, and it's one which is generated quite a lot of comment actually and interest, and it's really interesting and particularly relevant in discussions about the process of evergreening trademarks, the process of refiling old trademarks with similar specs to what they had before. I'll just take you through the chronology of the case as it's quite important. So back in 1998, Hasbro, which sells the Monopoly board game, which I'm sure you're familiar with, applied to register an EU trademark in Class 28, which covered toys, games, and playthings. Fast forward then to 2011, and Hasbro applies to register a second EU trademark for the word monopoly again. The specification is quite broad, but again, it covers games and playthings in Class 28. So it's a partial refiling of the 1998 trademark. Fast forward again to 2015, and Monopoly Hasbro becomes involved in a dispute with a Croatian competitor, a company called Creativini, who make the Drinkopoly game, which is a kind of drinking version of Monopoly. And in that dispute, Creativini tries to invalidate the later registered Monopoly trademark on the basis that it was applied for in bad faith. At the cancellation division in 2017, the outcome is that the application was not made in bad faith. The Croatian competitor then appeals to the Board of Appeal, and unusually the Board of Appeal convened an oral hearing which took place in 2019, and Hasbro gave evidence at that hearing. And following the oral evidence, the Board of Appeal said that Hasbro had acted in bad faith, and we'll look at why that finding was made a little later on. Hasbro then appealed to the General Court in 2021, and the General Court agreed and said that Hasbro had acted in bad faith in applying for its later trademark for the word monopoly. So let's have a look at why that happened. Now, importantly, the context for this case are the non-use provisions of EU trademark law, which I'm sure many of you will be very familiar with. But in very simple terms, the EU and UK trademark system works on a kind of use it or lose it basis. So trademark owners have a period of 5 years to use their trademarks. And if they don't use those trademarks within that 5-year period, then the trademark will be subject to revocation on the basis of non-use. Now, having heard the evidence of the Board of Appeal and having looked at the evidence from the Board of Appeal, the General Court held, and Hasbro denied this, but the General Court held that Hasbro had admitted and even submitted that one of the advantages of refiling its second trademark was that it wouldn't have to prove use of the older 1998 trademark. And that's really important in opposition proceedings and enforcement proceedings, because it's much easier to rely on a new trademark which isn't vulnerable to an attack from the other side. And what the General Court found was that Hasbro had an aim, one of its aims in refiling its second trademark was to avoid having to prove use of its old trademark, and therefore basically extend the 5-year grace period and circumvent the rules that are in place in the EU trademark system. The question was then whether or not that amounted to bad faith or not, and the General Court said that it did. So having a look at the General Court's findings, it's really clear from the judgment that a repeat filing does not in and of itself amount to bad faith. And that's really important. What the General Court says is that a repeat filing won't amount to bad faith on its own unless it is coupled with some other relevant evidence. The critical question therefore becomes, why did Hasbro apply for the later trademark? And was it applied for a purpose which falls inside or outside the kind of purposes of a trademark and the functions of a trademark? And the core function of a trademark is to indicate the origin of goods. What the General Court said about Hasbro was that it had admitted basically that filing the later trademark gave it administrative advantages in that it could avoid having to prove use of the old trademark. Hasbro also argued that this evergreening practice is a common one in the industry, but the General Court rejected that argument. It firstly found that Hasbro hadn't proved that it was a common practice, and secondly, the General Court said that this wasn't relevant, and just because everybody's doing something doesn't mean that it's acceptable. The General Court, in quite strong terms, said that Hasbro's filing strategy was inconsistent with the purposes of EU trademark law, and that it called to mind an abuse of law. So the later filed monopoly trademark had been made in bad faith and was therefore liable to be invalidated. So what are the implications of the judgment here? Well, the good news, if you are sitting there thinking that you've refiled trademarks yourself in the past, well, the General Court is very clear, as I said, and says on a number of occasions in the judgment, that repeat filings do not in themselves establish bad faith. Hasbro's error really was admitting to the Board of Appeal that one of the advantages of a repeat filing was to avoid the proof of use requirements. Once the court was aware of that and had that on the record, it was always likely to find against Hasbro. Now, one of the really interesting aspects of the case is the burden of proof in disputes such as this. And what is clear from the judgment of the General Court is that whilst a refiling won't in itself establish bad faith, it will do a lot to shift the burden onto the trademark owner. And what the General Court says is that if there is evidence of a repeat filing or a partial repeat filing, as it was in this case, then it is then for the trademark owner to provide a plausible explanation regarding the objectives and the commercial logic which it was pursuing when it made its trademark application. Hasbro, when faced with that burden of proof shifting towards them, found that it had to put a witness forward, basically, and to give oral evidence. And that started a chain of events which led to it admitting that one of the advantages was to avoid the proof of use requirements, which was ultimately fatal. And so the question then becomes whether or not it's better to record in some way the logic of the trademark filings that you've made, or why you've made them. And if not, to be prepared to give evidence at the time that a dispute arises, which gives a good explanation as to why the trademark was applied for, and making sure that those reasons fall within one of the kind of functions of a trademark rather than appearing to be an abuse of the system. So that's something to consider when filing trademarks now going forward, especially if they are repeat or partial repeat filings of old trademarks. Now, finally, just to conclude, Hasbro did seek permission to appeal this decision to the CJEU, but in December 2021, permission was refused. So that is the end of this case for Hasbro, and the end of the later filed monopoly trademark to the extent that it was applied for in bad faith. Thank you very much. I will now pass over.
Thank you very much. I'd now like to introduce you to Senior Associate Steph Taylor, who will be talking to you about the Chanel case.
Hi, I'm Steph Taylor, and I'm a Senior Associate in the Brand Designs and Copyright team. I'm discussing the case of Chanel versus the EU IPO, which was before the General Court of the European Union. The case began in September 2017. Huawei Technologies, who we will call the intervener, applied to register the stylized mark shown on the slide as a European Union trademark, covering a range of goods in Class 9, such as computer hardware and software, software for communications devices, voice recognition software, Wi-Fi and broadband operators, smartwatches, smart glasses, activity trackers, and mobile phones. The application was opposed by Chanel, who are the opponent, on the basis of Article 81B of the Regulation 2017/1001, which we'll call the regulation, and that ground is likelihood of confusion. This was relying on their earlier French figurative registration, which is shown on the slide on the left-hand side. The registration covered cameras, sunglasses, glasses, earphones and headphones, and computer hardware in Class 9. The opposition was also based on Article 8.5 of the regulation, namely reputation, and the opponent's earlier French trademark shown on the slide on the right-hand side, which covered a range of dissimilar goods such as perfumes, cosmetics, jewellery, leather goods and clothes, so the goods that Chanel are widely known for. The opposition was rejected by the EUIPO Opposition Division, and an appeal to the EUIPO Fourth Board of Appeal was similarly unsuccessful. As such, the opponent filed an appeal to the General Court of the European Union. The General Court dismissed the appeal in its entirety. The first ground of appeal, which was relying on the opponent's reputation and its stylised trademark, was unsuccessful on the basis that in order for a claim under this ground to succeed, there must be a finding of similarity between the marks at issue. Before the Opposition Division and the Board of Appeal, the opponent had sought to argue that the marks should be deemed to be visually similar on the basis that the applied for mark is rotated by 90 degrees, the applied for mark is visually similar to the opponent's earlier marks. This argument was not upheld by the Board of Appeal or the Opposition Division. The EUIPO and the intervener both submitted that when assessing similarity between the marks, the signs should be compared in the form in which they are protected, for example, as registered or as shown in the application for registration. The actual or potential use of the marks in another form is irrelevant. The General Court agreed with this principle, stating that in order to avoid uncertainty and doubt, the comparison can only be carried out on the basis of the shapes and orientations in which the signs are registered and applied for. Whilst the marks at issue share certain characteristics, such as a black circle, two interlaced curves inside the circle which intersect in an inverted mirror image, as well as a central ellipse which results from the intersection of the curves, the General Court found differences such as the two letters C in the opponent's mark and the letter H in the intervener's mark, the orientations of the central ellipse and the thickness of the lines. As such, the General Court found that the marks were visually different. The parties did not dispute the Board of Appeal's finding that an analysis of the phonetic similarity could not be carried out as the marks would not be pronounced. And finally, the mere fact that the opponent's marks and the intervener's mark included a geometric shape of a circle with a letter inside would not make them conceptually similar. And the General Court further stated that the presence of two letters C in the opponent's marks may call to mind the founder of the opponent's company, whereas the intervener's mark would be interpreted as a letter H or even two interlocking letters U. Turning to the opponent's second ground of appeal under likelihood of confusion, on the basis of the assessment above, the General Court agreed with the Board of Appeal and found that the marks were different overall. The key takeaway from this decision is the need to compare the earlier mark and the applied for mark in the forms in which they're registered or filed, irrespective of any possible changes to orientation in their uses on the market. Thanks a lot.
Thank you very much. I would now like to introduce you to Associate Sarah Sefton, who will be talking to you about the Oatly case.
Hi everyone, I'm here today to talk to you about a recent trademark decision that was in the IPEC last year, Oatly versus Glebe Farm. Before we go any further, I should probably disclose that Bristows did act on this case. We were acting for the defendant, Glebe Farm. If by some chance you kind of missed this last year, it was widely reported at the time, but if you don't know, Oatly are a giant producer of oat milk. They're one of the largest across the world. They make many different types, but of particular relevance to this case was the grey barista edition, which is shown here in the middle of the slide. This product alone had sales of over £38 million in the UK, so it's one of their best sellers. An extremely important product for them. On the flip side, Glebe Farm are a small British oat producer. They're based in Cambridge on their family farm. They mainly produce gluten-free oats. However, back in 2019, they launched an oat drink, which they called Oat Drink. It's pictured here on the slide as well. But in 2020, back in January, they decided to release an updated version of this, which they rebranded and called it Pure Oaty. As a result, Oatly sued Glebe Farm for trademark infringement and passing off. The trademark claim was based on 5 of Oatly's different registered trademarks, including words Oatly and then oat-ly, as you can see on the front of the cartons here. And there was also 2 that depicted Oatly cartons as well. Their allegations of trademark infringement were either based on a likelihood of confusion under Section 10.2 or unfair advantage under 10.3. I'll explain both of these in a bit more detail in a second. As you probably know, Glebe Farm did deny all the claims against them, and the case went all the way to trial last summer. The trial itself was picked up by the media, and it got fairly heavy coverage, I would say possibly off the back of the outrage at the time about Colin the Caterpillar. So, these kind of brand cases that the press is really, really interested in. So it was covered in lots of mainstream media, as well as being all over the food and drink trade press at the time. In addition, there was also a change.org petition, which was started to try and get Oatly to stop their case. Totally legally incorrect. There was no way it would work. However, it did actually receive over 131,000 signatures from the public. So clearly, it's an issue that many people feel pretty passionately about, let's say. So moving on to the Section 10.2 claim. So here, Oatly had alleged that the name Pure Oaty was too similar to Oatly and that consumers would be confused and think that Glebe Farm's product came from Oatly. So under Section 10.2, as you probably all know, you need to have use of an identical or similar sign in the territory. This is in the course of trade without consent on a similar or identical product, which gives rise to a likelihood of confusion. So the only real issues here between the parties were whether the sign Pure Oaty was identical or similar to the registered trademarks and whether there was any confusion. In terms of similarity, the judge found that there was a modest level of visual similarity between the two, limited to moderate oral similarity depending on which syllable you emphasize when saying Pure Oaty, purity. And in relation to conceptual similarity, the judge found a low degree of similarity, which derived only from basically the fact that oat was present in both words. He thought that the average consumer would see the sign as being a juxtaposition of pure and oaty, so 2 words coming together, whereas the claimant's mark would be perceived as a descriptive word, oat, plus ly on the end. So when it came down to it, on the confusion case, Oatly didn't actually submit any evidence of actual confusion between the 2 brands. Their witness was asked about this during cross-examination. However, he had to admit that they basically didn't have any evidence of actual confusion, and this was despite having over 300,000 followers on their social media channels. So basically, their confusion case relied on a handful of documents that the defendant produced during the disclosure. Most of these were typos, where people would refer to Glebe Farm's product as Pure Oatly, for example, by mistake. Ultimately, they all knew that they were referring to Glebe Farm's product and weren't mistaken, therefore, about the actual origin of the product. So as a result, the judge didn't think that there was any likelihood of confusion and dismissed the claim under Section 10.2. So moving on to Section 10.3, Oatly's main argument here was that Glebe Farm had deliberately chosen a similar name because they wanted to gain unfair advantage from Oatly's reputation. So, as you probably are aware, Section 10.3 claim requires a bit more than 10.2. You need a trademark with a reputation, use of a sign in the relevant territory in the course of trade without consent. The sign being used must be identical or similar to the registered mark and being used in relation to goods or services. On top of this, it must also give rise to a link between the sign and the mark in the mind of the average consumer and be causing one of 3 types of damage, so detriment to distinctive character, detriment to reputation of the mark, or unfair advantage, and all of this must be without due cause. Ultimately, the main arguments here between the parties were therefore whether Pure Oaty gave rise to a link to Oatly, whether any type of damage was caused, and whether there was any due cause. So looking at the disclosure documents that I just referred to, the judge did think that those typos and things were enough to show that people had made a link between Pure Oaty and Oatly. There were also a few examples on Glebe Farm's Amazon reviews where people had compared the 2 products together, which the judge thought showed that consumers basically had made a link between the 2 in their mind, and this was enough for Oatly. So this left them with having to show one of the 3 types of damage under 10.3. They did argue all 3, but the judge quite quickly dismissed some bizarre arguments in relation to detriment for reputation and distinctive character, and so I won't go into those in detail. So their main case was one of unfair advantage, with the claim that Glebe Farm had obviously intended to take advantage of distinctive character and reputation. Oatly's huge, everyone knows them. and therefore by rebranding their product to Pure Oatly, this was, clearly an example of unfair advantage. They based this claim partly on the name, but also the addition of the coffee cup, as you can see on the blue carton on the right here, the addition of the coffee cup on the front, the reference to barista coffee as well. The choice of blue was in contention, and also there's a shake me instruction on the top of the cartons as well. Case law in this area confirms that businesses are able to learn from competitors and can adopt similarities in approach and presentation. But when there's an intention to deceive, that's when it crosses the line and it goes too far, straying into infringement. Glebe Farm, their arguments therefore were intended to show the court that they had their own reasons for calling the product Pure Oatly, which had nothing to do with Oatly, and also that they had a kind of independent backstory for the design choices that they'd made. Glebe Farm were very upfront and honest in their evidence, and they did acknowledge that they were aware of Oatly at the time as being the market leader, but they emphasised that they did have their own reasons for all of the things that had happened, including the new name and the rebrand, which included things like the fact that Pure Oatly only has 4 ingredients, it's made up of pure gluten-free oats, so therefore they liked the play on words with purity, and Pure Oatly had been born from that. The reference to barista was natural because this was the market they were focusing on, and it's where they wanted to enter, and apparently having this on the front carries a premium because it means that the product reacts well with hot drinks rather than separating, which quite a lot of alternative milks are known for doing, and obviously that doesn't really work too well in a coffee shop. Ultimately, the judge found that being aware of competition is a legitimate thing and natural, and targeting a particular market itself is not taking unfair advantage in a trademark sense. He accepted all of Glebe Farm's evidence in relation to their choice of name and branding. He found that the word shake me was an instruction, and Oatly could not assert that these words were part of their distinctive character. He also said that Oatly couldn't possibly claim a monopoly over the word barista, which is clearly indicative of a product characteristic. And then he also made a comment about the image of a coffee cup being used and saying it's perfectly understandable given the market. So for all these reasons, he found that there was no suggestion or wish of an intention to get close to or let alone take advantage of Oatly's distinctive character, and dismissed the claim under 10.3. And as a result, the claim for passing off was also dismissed for pretty similar reasons. So altogether, as we'd say we're very happy with the results, having acted in the case, but it's hugely satisfying for a British manufacturer, having stuck to their principles in this sort of thing, to defend its right to use a descriptive element in its branding. The case confirms that in many cases, traders are able to use descriptive elements as part of this branding. This is good news. It's a very important tool for brand owners. It can be powerful. It helps consumers instantly identify what a product is and that sort of thing. So, that's why these sort of terms are quite often popular for branding. On the flip side, if you're a trademark owner and the use that you want to complain about is only the descriptive elements that someone is using, the decision does show that it might be difficult to prevent this in the future. However, Oatly didn't really change the law on this. It's consistent with previous case law, where the position is that the scope of protection of your trademark does not extend to circumstances where only the descriptive element has been reproduced, and where the distinctive part has been not produced. You're not straying into infringement territory. However, it is kind of worth brand owners remembering that just because a term is descriptive does not provide a defendant with a complete defence. The way it's used by both parties will also be relevant, and a likelihood of confusion can still arise. It definitely won't work as a blanket defence. However, the fact that it is descriptive is a good starting point. But don't forget, there is the potential for allegations concerning unfair advantage under 10.3, as were brought in this case. And on that sort of thing, the intention is going to be key. If you've used a term with the intention of gaining from it because of a more established brand that's already associated with that term, that will still be infringement. And if a case proceeds to trial, a defendant is going to be required to provide evidence relating to their reasons for choosing that term. In this case, the judge reviewed emails, design stories, and we had a witness cross-examined on it, just to ensure that there was no underlying intention. In this case, he found that there wasn't, but that might not always be the case. So as a rule, we'd consider that as a good starting point. You can potentially use descriptive marks. However, your intention and the context behind it will be kind of key in whether you're straying into infringing territory. and the decision in Oatly hasn't changed that.
Thank you very much. I'd now like to introduce you to Associate Jake Palmer, who will be talking to you about the Wirex case.
Hi everyone, my name's Jake. I'm an associate here at Bristow's in the brands team, and I'll be talking about Wirex and Cryptocarbon. So this is a case about neologisms, which just means a newly invented word for a new product or service, evidence of goodwill for the purposes of passing off, and cryptocurrency. So just by way of background, Wirex and Cryptocarbon both offered a cryptocurrency cashback reward scheme under the mark CryptoBack. So basically how that worked is if their users spent money on a Wirex or Cryptocarbon credit card, they would receive some cryptocurrency as cashback. So in terms of the mechanics of the dispute, Wirex had a trademark for CryptoBack, and they alleged that Cryptocarbon had infringed that. Cryptocarbon counterclaimed, saying that the Wirex's mark was invalid based on 54A and 54A of the Trademarks Act, relying on their earlier goodwill in CryptoBack, and also a bad faith element which fell away, so I probably won't mention again. But helpfully, the Cryptocarbon conceded that if Wirex's trademark was valid, they had infringed it. So as a result, the central and really only question became whether Cryptocarbon owned goodwill associated with CryptoBack as a trading name at the filing date of Wirex's trademark. So probably the most interesting part of the case was Judge Hakon reviewing whether CryptoBack might be considered a neologism or descriptive. So as I briefly touched on before, a neologism is a newly invented word. So Judge Hakon was concerned whether a newly invented word could be used as a trading name. And in doing so, he considered a really old case called Linoleum Manufacturing Company and Nairn. So just by way of background, linoleum is a solidified oil substance. I hadn't heard of it before, but apparently most people have, also known as lino. And the original inventors of linoleum had tried to assert goodwill in the word linoleum. And it was held by the judge in that case that linoleum had taken on the meaning of that solidified oil product, and it only had a secondary meaning of being the manufactured solidified oil product of the claimant, and therefore it was a neologism. And applying that to this case, Judge Hakon said that a neologism, especially where used in relation to a new product or service, may be taken by the public to be a new word for that type of product or service. So in this case, the concern was that consumers would perceive the word CryptoBack as just being descriptive generally of a service whereby you get cryptocurrency in a cashback reward scheme, rather than specifically that of Cryptocarbon. Similarly, but slightly different, Judge Hakon was concerned that CryptoBack could be descriptive, given that it's just a contraction of cryptocurrency and cashback. And the concern here is obviously if it's purely descriptive, it can't serve an origin function and refer to Cryptocarbon service. Both of these kind of led to the same crucial question for Judge Hakon to consider, which was whether CryptoBack could be considered distinctive of Cryptocarbon services at the filing date of Wirex's trademark. So another way Judge Hakon put this was, if the public see or hear CryptoBack at the filing date, do they think just generically of the cashback reward scheme, a cryptocurrency cashback reward scheme, or do they think specifically that same scheme as applied to but sourced from cryptocarbon. The logo on the left is cryptocarbon's logo, just to explain that diagram. So on that same question, what that meant for cryptocarbon is that they had to prove through evidence that through their use of CryptoBack, the public would perceive CryptoBack to be distinctive of their services, rather than just a generally meaning cryptocurrency cashback. And in the judgment, Judge Hakon explained that more use might be required for descriptive marks in order to show distinctiveness, and it's possible to sort of infer from the judgment that he didn't quite go as far to say it, but something similar might apply to neologisms. So that's the meaning of this scale on the right. You can see in grey just kind of a normal non-descriptive mark, and the use that might be required for it to be distinctive of the mark owner's services or product. And you can see higher thresholds are required for descriptive marks and possibly also for neologisms. So in the end, this wasn't really a very on balance difficult case in the sense that cryptocarbon's evidence fell way short of apparently any of these thresholds, but certainly the higher ones. And the reason for this was that their evidence just didn't show if or how CryptoBack had been presented to the public. And this was really important because what Judge Hakon had to consider was whether the public would perceive CryptoBack to be distinctive of cryptocarbon. And if you don't have evidence of how CryptoBack is being presented to the public, the court couldn't say that it was distinctive. So finally, just a couple of takeaway points. So the first and probably most obvious is just to be careful of these newly invented words when a new product or service is invented. So think here of your linoleum example. The second point would be to be careful about how brands are used. You need to make sure you're using them as a badge of origin and not descriptively. So in this case, Cryptocarbon gave evidence an article that referred to CryptoBack, but Judge Hakon decided that on balance that the article was referring to the service generally rather than specifically that service provided by Cryptocarbon. A third point would be it's really important to give evidence of how a mark is shown or presented to the public. So the big reason for the failure of the evidence here was that Cryptocarbon just hadn't done this. So, for example, they'd given all sorts of statistics about sales figures and number of emails sent to UK consumers, but neither of those showed how CryptoBack was actually presented in the email or say in the invoices. So the courts couldn't decide if that was distinctive of Cryptocarbon services. Finally, it's possible that there'd be similar implications for neologisms as trademarks. Interestingly, the descriptiveness and the neologism point were pushed at trial by Judge Hakon rather than Wirex. And you can see that Wirex were in a sort of validity squeeze of their own trademark because by attacking Cryptocarbon's CryptoBack, they were, for being descriptive, they were potentially harming their own trademark. So that's all from me. Thanks very much for listening.
Thank you very much. I'd now like to introduce you to Senior Associate Abby Wise, who will be talking to you about the American Eagle case.
So the Larwan Scott decision, which was issued back in 20th of January 2021, shed light on the governing law for passing off claims under Rome II, which sets out the rules which determine the law which govern non-contractual obligations in most civil and commercial matters. And this is particularly important due to Brexit. So in this instance, Lowe and Scott and American Eagle Outfitters are both clothing retailers and both use an eagle logo as part of their insignia. The parties had sought to resolve their differences outside of court initially, and following a meeting between the parties, they came up with this memorandum, which included considerations on their respective use of the eagle logo. Shortly after that, negotiations did actually break down between Lowe and American Eagle, and American Eagle decided to take them to court in Pennsylvania, where they obtained a decision from the court in the US declaring that the memorandum itself constituted a valid agreement. In August 2020, Lowe and Scott commenced proceedings against American Eagle in the UK for breach of contract and passing off. The jurisdiction of the English courts was contested by American Eagle, stating that it should be set aside on the basis that the jurisdictional gateways were not satisfied under CPR 6.37, which deals with an application for permission to serve the claim form out of jurisdiction. So despite the existence of a memorandum which was subject to Pennsylvania law in earlier US proceedings, the High Court concluded that the English courts were the appropriate forum for the trial of a passing off dispute. And they gave 3 reasons for this. The first being that the passing off claim had a real prospect of success, so it raised a serious issue to be tried. It was accepted that Lowe had established goodwill in respect of the eagle logo in the UK. Furthermore, the logos were closely similar and were both being used on clothing, so there was an obvious potential for confusion. The absence of evidence of actual confusion was not enough at that stage to detract from the claim having a real prospect of success. Following an analysis of the connecting factors, the judge was satisfied that England and Wales were clearly the appropriate forum to decide on the passing off dispute. Although, of course, the contract and passing off claims had to be considered separately, as the contract head of claim would ultimately be governed by Pennsylvanian law on the basis that this was not contested in the US proceedings. Important factors to decide that the English courts and English law would rule over the passing off dispute were that the case included a tort claim which was committed in the UK concerning goodwill within the jurisdiction and alleged infringements in the UK. Importantly, while the agreement concerned the parties' general relationship, passing off claims did not arise from or under that agreement. The applicable law to the passing off claim would have been Rome II on non-contractual obligations. In particular, it was decided that Article 6 of that regulation regarding unfair competition and acts restricting free competition would apply to passing off claims instead of Article 8 regarding infringement of intellectual property rights. This was decided on the basis that the cause of action which protects goodwill is not an intellectual property right, and passing off is not the infringement of a right. It follows from the application of Article 6.2 that the applicable law would be that of the country in which the damage occurred. So in this instance, that was in England and Wales. With this particular case, it is important to note and bear in mind that when determining governing law and ultimately the relevant forum to decide the dispute, Article 6 of Rome II would be applicable to passing off claims. This is because passing off would fall under the head of unfair competition claims. The test under Article 8 on infringement of intellectual property laws differs, and the resulting governing law may also be different as it is the law of the country from which protection is claimed that applies. The existence of a contract between parties and prior decisions in foreign courts in respect of that contract do not necessarily preclude the jurisdiction of English courts. Most importantly, passing off claims do not arise from or under an agreement, so the passing off aspect of the parties' relationship in this case was not governed by a contract.
Thank you to all of our speakers today. I hope you enjoyed the 5 case reviews, and I hope you enjoy the wider publication. It goes without saying that if you have any comments or questions about this webinar or the wider publication, please do not hesitate to contact any member of the team. Hopefully we'll all be back together next year in person. Take care.